Please mute them. Please mute them. Kindly, all of you, mute yourself. A very warm good evening to all. Today's topic, transit anticipatory bail. You all must have heard about the anticipatory bail, but transit anticipatory bail is something new which is not defined under the law. Now, when something is not defined under the law, we call it judge made law or judge mechanism about a device or about a usage which can be used for the common public, common litigant. Now, when we speak transit, the word itself meaning the travel. So, whenever there is a transit remand. Now let's understand from the meaning what is the meaning of transit remand. Remand means the police takes the accused person to the court. Now everybody knows under the article 22 of the constitution, a person who is arrested should be produced within 24 hours to the nearest police station. That is a law. So you read Article 22, make a note of it. So if you read it, you will say there are guidelines about the arrest of the person and also about his protection of his liberty. Now in this case, whenever a person goes for anticipatory bail, there is a possibility that in between he can be arrested. Suppose an FIR is lodged in the Tamil Nadu and the person is residing Maharashtra, Mumbai. Now, both these states are very far away, and there is a possibility the person who is traveling from Maharashtra to Tamil Nadu, he will not have an access to the local lawyer where Tamil Nadu to apply for anticipatory bail. In those cases, he understands. Now he will go to where if he suppose he is staying in the Mumbai, then he can go to the Mumbai Session Court or the High Court. There is a concurrent jurisdiction, but first you have to approach the subordinate court, that is Session Court, for the anticipatory bail. But it will be uh, transit anticipatory. The reason behind that because the FIR is lodged in the Tamil Nadu. When the FIR is lodged in Tamil Nadu, this court will not cannot grant you bail or anticipatory bail. There is no question of this courts in Maharashtra can give you the anticipatory bail while in transit. Now, the anticipatory bail application can be filed only in Tamil Nadu, but the time required for traveling to from Mumbai to Tamil Nadu, a place where FIR is lodged, that time you can be protected, and that is where the transit anticipatory bail application comes into picture. So always remember. Now, if you try to find out in BNSS now, that is a new law, or the old law CRPC, Criminal Procedure Code, you will not find the word transit anticipatory bail application. Now, when you don't find it, why it is there? But there are many things which are not written in the law. They are the inherent powers of the court, where the court can consider the application or the prayer of the litigants. So this is judge-made law or the judge-made mechanism to protect the liberty of the person who is apprehending arrest, who is seeking. There may be false cases, there may be some good reason. Suppose there is a lady, pregnant lady. I mean, if the FIR is lodged in Tamil Nadu, how she is supposed to travel there? Then she should have a time to appoint a lawyer, to apply for the anticipatory bill. That is the right of every litigant against whom complaint is lodged. Because every complaint may be true or may not be true. Every accused under the Indian law will be given a chance to prove his innocence or to put up his case from his side. So always remember that whenever there is an FIR lodged in another state, this state, another state where you or your client is residing, has every right to apply for transit anticipatory bail application. This application, if granted, if allowed by the court, only for the period traveling to that, you can be, it may be 4 weeks, it may be 6 weeks, it may be 2 weeks also. If it is just Maharashtra and Gujarat, which is a matter of 6 to 9 hours travel, even if the interior part of Maharashtra and the Gujarat, they are the neighboring states. So it is very easy to understand and easy to apply. Now, lot of people say that we have hardly heard the transit anticipatory bail application. But there are many cases. The recent case of Supreme Court is Priya Indoria versus State of Karnataka. Let me read out one small paragraph from it, but it is the basic information given in one para. I'll be reading it. Just a minute. Let me share it. I'm finding it a little difficult. Kindly bear with me. In this case, we are concerned with what is loosely termed as transit anticipatory bail. As we have seen, the expression anticipatory bail is not defined in the CRPC, though it is traceable to section 438 of CRPC. CRPC is now replaced by the BNSS. This court in Balchan Jain had defined anticipatory bail to mean bail in anticipation of arrest. The Constitution Bench in Gurbakh Singh, Sibia. These are very important cases, Gurbakh Singh. Try to read it. Has held that filing of FIR is not a condition precedent for exercising power under section 438 of CRPC. This is not related to the anticipatory bail actually. Suppose there is no FIR filed. I spoke that FIR. Suppose even if he or she is apprehending arrest, then in that case also it can be. She can apply for the bail. Has held that filing FIR is not a condition precedent for exercising power under section 430 of CRPC. 430 of CRPC. What is required for invocation of power under section 430 is that the person seeking anticipatory bail should show reasonable belief of imminent arrest. If the expression anticipatory bail is not a defined expression, then it is quiet but natural that the bail has that the larger expression transit anticipatory bail would not find any exposition in the CRPC. Perhaps the need and necessity for transit and anticipatory bail has occasion because the police has been conferred power under the CRPC to pursue an accused in other jurisdictions. Immediately upon arrested person, just a minute, immediately upon affecting the arrest of a person outside the jurisdiction where the offense is registered, the police is obligated to secure a transit remand. When I said the word transit anticipatory bail has come from transit remand. There is a transit bail as well. I'll come to that with one example. The arrested person has to be produced before the nearest magistrate. If such a magistrate finds that he has no jurisdiction to try the case in which the accused has been arrested, he may order the accused to be forwarded to a magistrate having the jurisdiction to try the case or to commit it for trial. Thus, the police is obligated to secure transit remand of the accused for taking him from the place where he is arrested to the place where the crime is registered for production before the competent magistrate in terms of requirement of Article 22, which we discussed in the beginning. Article 22 is about presenting, producing, and person detained, arrested within 24 hours of his arrest. As we have detention is a different word, but once the person is arrested, he should be produced before the nearest magistrate. As we have already noted, the primary purpose of such a transit remand is to enable the police to shift the person in custody from the place of arrest to the place where the matter can be investigated. It appears that from the aforesaid requirement of transit remand has arisen the necessity of transit anticipatory bail. इनका कहना है कि ट्रांजिट रिमांड से ट्रांजिट एंटिसिपेटरी बेल का उद्गम हुआ है. For an affected person cannot be without a remedy. So let's go back to the transit remand. What is transit remand? Suppose a person is residing in the state of Gujarat and there is a FIR lodged in the state of Rajasthan. Now, from if the police comes from the Rajasthan, now I'm talking about arrest, not anticipatory bail. So, suppose the police comes from the Rajasthan, that is from the out of state, they will approach the local police, also take the local police and show the warrant and arrest the person. And from now, Gujarat to here, Rajasthan, they may have a 14 hours, 20 hours journey, or maybe sometime more than that, they may require to travel. If it is not within 24 hours, they have to apply to the nearest magistrate where in the Gujarat itself, produce the accused, say, we are taking this person from Gujarat to Rajasthan and give us 36 hours or 25 hours or 30 hours time limit for transit remand to be taken. Now here it will be transit remand. Now I will add one more thing. When a police applies for transit remand, same time accused lawyer can also apply for the transit bail. Now just opposite to it is anticipatory bail. When you are applying for anticipatory bail in a, suppose in Mumbai the person is apprehending arrest, there is a FIR lodge, then he will go to session court and then the high court. Here he will apply for anticipatory bail. But if he has to apply anticipatory bail for FIR lodge in some other state, again then anticipatory bail for transit remand, because उसे डर लग रहा है कि in the process of finding out the jurisdiction of that court in other state, he may be arrested while he is traveling. That is why transit anticipatory bail, traveling, while traveling he should have the security that he will not be arrested. So it is actually not very difficult. But if you know transit remand, section Article 22 of the Constitution, and there are few judgments like Indoria judgment, Priya Indoria judgment, which is a recent judgment of the Supreme Court. If you read all the judgment, there is also I think Jacob's judgment, Bombay High Court 2 judgment. This all judgment, I'll share this judgment in the group later on. So you will get an idea what is transit remand, transit anticipatory bail application, and transit bail. I will try to also explain this in one of the case of mine. I think about there were no that time except email, there was nothing. WhatsApp was not there. It was I think about maybe more than 15 years back. I was a raw junior. One person was arrested in Mumbai for a case in Jalandhar, and check bouncing case. It was a check bouncing case, and their non-bailable warrant was issued against him. That the police came here and they produced him before the Bandra. I was engaged by one senior lawyer to appear here because he was unable to travel. He was somewhere else. So I applied for the transit bail, and in between, see, warrant, there was a warrant, and I could have applied for cancellation of bail. So there were too many options to us, but being a junior I was not very sure also. But it was a cancellation of bail, then the judge of course will say the warrant is issued by somebody in Jalandhar, can this warrant be cancelled here? But I had occasion to look into the complaint and speak to my client. That's why I said client meeting is very important. I asked him what is the amount check involved. He said it is 65,000. So about 15 years back also I told him, even if you police takes you from here to there, you will be engaging a lawyer there. Why not pay 65,000? We did NEFT that time, which was available at time of 65,000, and that person from there sent a email that I will withdraw the case. I have no objection if his warrant is cancelled. That is how warrant was cancelled. He withdrew the case in Jalandhar that way. So this is what out of box thinking for a lawyer to help your own client. So if the amount is very less, there was no meaning to take this man from Mumbai to the Jalandhar, and he will spend the equal amount of money, same amount, similar amount of money in doing that. So always remember one thing, that always have a good client meeting. So anticipatory bail is a different and transit anticipatory bail is a different. Transit anticipatory bail always for a small period, for a period which you have to travel from this place to this place. I have also seen cases where the lawyer came before the court and the client is taking to the Pune or to Nasik, and the police also brings because the lawyer also insists that हमें bail लेना है, transit bail लेना है. Now this is proper bail, not anticipatory bail. Then the judge has said from Mumbai to Pune it is 4 hours, 3 hours, and from Mumbai to Nasik also about 5-6 hours. So where is the question of keeping the accused in the police custody for 24 hours? So you can produce very well in the 24 hours. Now let me tell you some one more thing. Suppose the client is arrested 2 o'clock in the afternoon, and they reaches to the Pune at 8 o'clock or 7 o'clock. By the time courts are closed, so where do they go? There are on duty magistrate which also works. See, criminal court never sleeps, it is always on. Criminal court को कभी छुट्टी नहीं होती है, it is always working. Also, those who are, I think Archana and others are senior here, they also know that there is a holiday remand. If somebody is aware, there is a holiday remand. Go and attend holiday remand of your area. Now, in holiday remand, also they can produce it. Suppose even if it is Sunday or non-working Saturday, or they can go to magistrate house to produce him. पुलिस लेकर जाती है मैजिस्ट्रेट के घर पर एंड दे चेक एंड वो वहां पर भी ऑर्डर्स होते हैं कि यस प्रोड्यूसिंग. सो इट इज आर्टिकल 22 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया इज वेरी वेरी इंपॉर्टेंट पार्ट. एंड सी, नॉर्मली हम लोग सोचते हैं क्रिमिनल मैटर्स में हमको सीआरपीसी बीएनएसएस पढ़ना है, आईपीसी पढ़ना है, बीएनएस पढ़ना है. नो, you have to read the constitution of India, which is the base of all the law. I would say the father of every law in our country. So this was about the transit anticipatory bail. We would cover this with more judgments in the future with a special lecture. So now next to the over to the Kapil. Kapil, let me share the judgment. Kapil is going to read a judgment which is, I think, more than 100 years old. But I have chosen this judgment because I felt the language was still worth visiting. It is a Madras High Court judgment, cites 9 and cited by 10. 10 बार cite हुआ है. तिरुवंबला डेसिकर गनाना संबंधा वर्सेस चिन्ना पंडरम एलियास मनी कवच का 1915. साल देखिए आप 1915.
Ma'am, before starting this, I have a doubt. Can I ask?
जी जी बोलिए.
Ma'am, as per Article 22,
नहीं
the
नहीं नहीं
accused...
नहीं, this is not about related to this. That we'll discuss after the meeting.
Okay, ma'am. Fine.
Start this appeal relates to.
Okay.
अच्छा, read the judge name.
Yes, ma'am. Okay. Tiruvambala Desikar Ganna Sambandha versus Chinna Pandaram alias Manni Vachaka on 20 December 1915. Judgment by John Wallace.
Yes, just wait.
The appeal
See,
relates to the
just
headship
a minute,
of a
just a
wealthy
minute,
mutt or
just a
adhinam
minute,
of...
just a minute. I said this judgment is of 1915. तो सीजे में उस समय वहां के चीफ जस्टिस रहे होंगे वो मद्रास हाई कोर्ट में, तभी 4 भागों में सुप्रीम कोर्ट बटा हुआ था. देयर वाज नो हाई कोर्ट.
Alexa, pause.
यस, तो जॉन वॉलिस सीजे, तो इट इज अंग्रेज जज साहब थे तभी. आप पढ़िए अभी जजमेंट को. ओके, काइंडली कंटिन्यू.
Okay. This appeals relates to headship of wealthy mutt or adhinam of Dharmapuram in Tanjore district, the affairs of which are unfortunately the subject of endless litigation before us.
Slow.
Ganna.
Speed कम थोड़ा.
Okay. Shiva Ganna, who was for many years Pandara Sanadi or head of the mutt, filed original suit number 86 of 1906 in the subordinate court of Kumbakonam to set aside a deed of relinquishment Exhibit S, executed by him in 1903 in the favor of Manni Vachaka. The defendant in this suit, whom he had previously ordained or nominated as Junior Pandara Sanadi, with the right of succession according to the custom of institution. Shiva Ganna died shortly after the institution of the suit, and the present plaintiff sought to be brought on the record as a legal representative, on the ground that the day before he died, Shiva Ganna had ordained him and executed a will in his favor. It was held by subordinate court, and by this court on appeal that the plant in the original suit number 86 of 1906 called in question the right of the defendant to be Junior Pandara Sanadi as well as his right to the enjoyment of the mud properties under the deed of the relinquishment. And it was accordingly ruled in the instance of the present plaintiff and the suit did not abate on Shiva Ganna death. And under section 367 of CRPC, the court stayed the suit and left the plaintiff to bring the present suit against the Manivachaka to establish that he is the legal representative of the deceased Pandara Sanadi and so entitled to continue original suit number 86 of 1906. The suit necessarily involves the question whether the defendant Manivachaka had been lawfully appointed Junior Pandara Sanadi and also the further question whether he was lawfully removed during the lifetime of Shiva Ganna as if not, he and not the plaintiff is the legal representative of the deceased. Accordingly, pleadings and issues in this case cover much of the same ground as the principal suit. During the pendency of this suits, the defendant Mani Vachaka had also died after nominating and ordering a successor who has been brought on the record as the legal representative. So that the contest is now between the plaintiff claiming as a nominee of Shiva Ganna and the present respondent claiming as the nominee of Mani Vachaka. The subordinate judge has dismissed the plaintiff's suit on the two grounds that Manivachaka must be taken to have validly appointed and not have been removed, and that he was consequently Sivaganna legal representative, and secondly on the ground that the plaintiff has failed to prove the will and ordination on which he relies to establish his character of legal representative. Either of these findings is sufficient to depose the present suit. As pointed out by the subordinate judge in very careful judgment, this case in the last stage in a long dispute between the defendant and the opposing faction in the mud headed by Somasundara Thambiran at one time belonged to the institution and subsequently became the head of the wealthy Tirupandanal Mutt. These opponents of the defendant endeavor in the first instance to prevent his nomination as a junior Pandara Sanadi and afterwards to get that nomination revoked. In the course of the dispute, we find Sivaganna, a weak and feeble old man, embarrassed by the load of debt accumulated by his management and acting under influence first of the one side and then of the other. We find him ordering and nominating the defendant on 22nd April 1900, Exhibit 23, in the spite of the pendency of suit subsequently dismissed to prevent him from making appointment, and then 27th September 1900, giving him from making the power of attorney to the defendant. On 19 June 1901, he cancelled the power to take possession, cancel the power of the Exhibit MM on which contained injurious charges against the defendant. The defendant on 2nd July 1901 by Exhibit UUUU surrendered the properties he had taken possession of under the power. And few days later, Shivagana executed X, by which he withdrew the charges against the defendant containing Exhibit MM. 2 months later, 12th September 1901, he purposed by Exhibit K to remove the defendant from the position of the junior Pandara Sanadi on the account of malversation and the vague charges of sexual immorality on which no particulars whatever were given. Thus challenged the defendant preferred a criminal complaint against him for defamation and also called a civil suit, original suit number 74 of 1901, questioning his alleged dismissal. The next thing was that the compromise was arranged. The defamation case was withdrawn and the suit was settled by Razinama. Exhibit B-2, in which he was recited the defendant Shiva Ganna had a further inquiries asserted the accusation made against Mani Vachaka were groundless and that there were no reasons for dismissing him, and by which his right was recognized and was further agreed on the certain properties belonging to the mutt should be handed over to him. On this degree, Exhibit P-1 was passed on 2nd January 1902, declaring him to be the junior Pandara Sanadi and deed of dismissal to be null and void, the restraining Shiva Ganna from appointing anyone else as a junior Pandara Sanadi. 18 months later, on 7 June 1903, Shivaganna executed a deed of relinquishment, Exhibit S, by which he retired in favor of the defendant and some time afterward made his way to Banaras. He returned from Banaras in 1906 and went to stay with the defendant enemy Somasundaram at the Tirupandanal Mutt, whence he sent the defendant 12th May 1906 notice Exhibit T. On this intention, file a suit for declaration that Exhibit S was invalid and recover the Mutt properties. A suit was subsequently filed as original suit number 86 of 1906 for the purpose. It has been contended before us the Exhibit T amounted to be a fresh dismissal of the defendant from the office of the junior Pandara Sanadi, but we do not so read it. There is, however, oral evidence that on two occasions after the written, Shivaganna purported to dismiss the defendant from the office also. Shivaganna died in the morning of the 1st December 1906 and alleged by the plaintiff. On the evening of the 30th November, as alleged by the defendant, according to the plaintiff case, Shivaganna conferred Abhisegam upon him and 30th and also execute W, nominating him as the successor.
और ये कोई
But
वो लोग खा लेने दे दो वो लोग को
but
4
the
घंटा
fou-
लगा नहीं
जस्ट अ मिनट, उनको शांत कीजिए।
मैं अकेले खा लेगी
कंटिन्यू, प्लीज कंटिन्यू।
but the finding of the subordinate judge is that alleged by Abhisegam and will not have been proved. Thus, this is a brief statement of the fact which are more fully set out on the judgment of the subordinate judge. The fifth and the sixth issues dealt with the validity of the defendant's original appointment and with which the question whether Shivaganna was entitled to dismiss him referring to the first dismissal under Exhibit K. It appears from a note made by the subordinate judge on the record of the evidence that he was arranged, probably at the suggestion of the defendant pleader, that the evidence on these issues to be reserved until after disposal of the issues 7 and 8 as to be compromise decree on the original suit number 74 of 1901, which was found in the favor of the defendant who make issue and sixth unnecessarily. It will be convenient to consider the first place where the compromise decree in the original suit number 74 of 1901 is valid and binding. As already stated, it was entered into after Shivaganna had purported to dismiss the defendant by Exhibit K, and the defendant had replied by filing and a complaint of the defamation and a suit to declare the alleged dismissal illegal. The subordinate judge has found out that it was brought about after protracted negotiation on the independent advice of a person who had the interest of institution at heart and not by the means of any pressure or operation on the part of the defendant. If Shivaganna was not in a position to justify the charges he had made against the defendant, it was eminently proper for him to withdraw them instead of committing the mud or further ruinous litigation. I do not, however, consider it necessary to pursue the matter further because, in my opinion, consent degree in the original suit 74 of 1901 was binding on Shiva Gunna and was also binding on the present plaintiff who claims through him. And even if there had been any grounds for setting aside by the suit, such suit became barred during the lifetime of Shiva Ganna. A consent decree is binding on the parties to the suit until it is set aside just as much as if it had been passed after contest. Fateh Chand versus Narsingh Das, 1915, 22 CJLJ citing on the South American and the Mexican company, ex parte Bank of England. The effect of the consent decree in the original suit number 74 of 1901 is to establish as against Sivaganna and those who like to present plaintiff claim, though it the defendant had been duly appointed junior Pandari Sanadi and continued to hold that the office at the date of the decree. Consequently, unless he was subsequently removed, he was junior Pandara Sanadi at the death of Shivaganna and then become legal representative and entitled to succeed to his office. As regard alleged illegality in the compromise degree insofar it restrains the plaintiff from removing the defendant in the case future misconduct. I do not think that it will be any ground for setting aside the decree altogether in a suit by Shiva Ganna for the purpose. For this does not affect the consideration obtained by Shiva Ganna entering into the compromise. See also Carne versus Whitehaven Colliery, QB 1 QB 700. It is, however, found by the subordinate judge that after his return from the Benares in 1906, Shivaganna purported to dismiss the defendant, and it is contended that these dismissals were operative. To succeed in this contention, it will be necessary for the plaintiff to get over the deed of relinquishment Exhibit S executed in 1903 by Shiva Ganna in the favor of the defendant, which is attacked among other ground and is having to be procedured by the coercion and undue influence and so liable to set aside in the present suit. However, it is however unnecessary to consider the question because assuming Shiva Ganna continued to hold the office of Pandara Sanadi after the execution of Exhibit S and that such was empowered to dismiss the defendant from the office of Junior Pandara Sanadi. It is not shown that the defendant received any notice or was given any opportunity of answering the charges on which Shivaganna purported to dismiss him. It has been contended before us that the defendant only held office at the pleasure of the Pandara Sanadi, and consequently the later it was entitled to dismiss him without giving him an opportunity of customary being heard. The nomination and ordination of a junior Pandara Sanadi is the customary manner of proving for the line of the succession in the mutt of this kind, and it is not shown that the Pandara Sanadi has power of arbitrary dismissal, while on the other hand, it has been held in a previous suit relating to the dismissal, sorry, arbitrary, the institution that he may dismiss for the good cause. In Vidyapurna Tirthaswamy versus Vidyanidhi Tirthaswamy, 1904, ILR 27, MAD 435, where the question whether a Pandara Sanadi fortified the position as such by the reason of lucency, recourse was had analogies under canon law, and applying those analogies, in this case the position of the Pandara Sanadi during the lifetime of the elder would appear to be at the co-adjudicator, the right of the succession, a right of which cannot be deprived except for the grave cause. When an office is held at the pleasure, in the incumbent may be removed even the charges of the misconduct without any opportunity of being heard, because he is removable at the pleasure of without any misconduct at all. But all other cases, the objection for want of notice in the language of an old case can be never be get over. The laws of God and the man both give party opportunity to make this defense if he has any. Rex versus Chancellor and the Master of the University
Wait,
of the.
wait. See, the language. The laws of God and man both give the party an opportunity to make his defense if he has any. See the language. That's why we should read the Old Judgment. Thank you so much, Kapil. Very well read.
Thank you, ma'am.
Thank you. Just a minute. Good reading.
Ma'am, Rex means king, right?
We will speak later. No questions in between the meeting because there are more than 250 people.
Yes, ma'am.
So in the end, we can take up questions. Okay. Now we'll go to vocab part. Sangapriya and Jain from my office have done this to help me out. The first word is it visible?
Yes, ma'am.
Yeah.
Yes, ma'am.
Yes, ma'am.
Okay. Impetus, 41 number. A force or motive that sparks legal action or legislative reform. Now, impetus. Let's understand this meaning force or motive. Mostly it will be a force. The landmark Supreme Court ruling acted as an impetus. मतलब एक उसने इसको मोटिव नहीं हो गया, मोटिव का मीनिंग अलग हो जाता है इन क्रिमिनल में. So landmark Supreme Court. So we will use the force spark legal action. Landmark judgment ruling means उसका मतलब भी judgment है, acted as an impetus for sweeping judicial reforms across the state court system. ऐसा कोई सिस्टम बना जो सुप्रीम कोर्ट का जजमेंट आया जिसके वजह से सारे जुडिशियल रिफॉर्म हो गए अक्रॉस द स्टेट कोर्ट सिस्टम, कोर्ट में सारे हो गए. जैसे अर्नेश कुमार वर्सेस स्टेट ऑफ बिहार आया, अप टू 7 इज देयर इज नो अरेस्ट नाउ. नेक्स्ट इज ब्रेजनली. बोल्ड और शेमलेस, मोस्टली इसको शेमलेस ही बोलते हैं लेकिन बोल्ड और अनअपोलोजेटिक वे, बोल्ड तो रेयर इसमें होगा. वी हैव रीजन टू बिलीव दैट Samay Raina has taken the court for a ride and has brazenly violated the rights of honorable court. Next, probe. Everybody know probe का मतलब क्या होता है? Investigation. A formal systematic investigation or inquiry. Sri Ram Janmabhoomi Tirth Kshetra Trust on a batch of public interest litigation. See the word batch of public interest litigation. Petitions seeking a probe by the Central Bureau of Investigation into the financial irregularities and missing funds at the temple. Sentence is not completed, but you have to understand meaning. Opined. द एक्ट ऑफ स्टेटिंग और एक्सप्रेसिंग ओपिनियन, ओपिनियन से ही ओपाइन वर्ड हुआ है. सुप्रीम कोर्ट जजेस, सुप्रीम कोर्ट जज ओपाइंस that bail matters should end at the high court. Retrospect. Prospective सुना है, वैसा ही है retrospect. Looking back at the past. Looking back. पुराना. Supreme Court rejects state's plea against retrospective pay hike for Delhi High Court law researchers. Levy. Those who are reading newspaper, they know what is the meaning of levy. Tax levy करते हैं ना. Legally authorized imposition and collection of a mandatory fee, tax, fine or penalty. The Central Consumer Protection Authority, see now you, what is CCPA? CCPA has issued an advisory stating that hotels and restaurants cannot levy additional charges such as LPG charges, gas surcharge or fuel cost recovery by default. Next, stance. लीगल पोजिशन, आपका स्टैंड पॉइंट क्या है? सी, स्टांस भी लिख सकते हैं, स्टैंड पॉइंट भी लिख सकते हैं. द कोर्ट फाउंड मेरिट इन कमर्शियल टैक्स डिपार्टमेंट स्टांस एंड रूल्ड इन इट्स फेवर. It's easy, but then also you need to understand again. The court found merit in the commercial tax department stance. उनका स्टैंड पॉइंट क्या है या लीगल पोजीशन क्या है? एंड रूल्ड इन इट्स फेवर, उनके फेवर में जजमेंट दिया. स्क्वांडर, टू वेस्ट मनी और अपॉर्चुनिटी, मतलब या तो ध्यान नहीं दे रहे हो या वेस्टेज कर रहे हो, बट या तो मनी या अपॉर्चुनिटीज. द प्रेजेंट पिटिशन इज अ बोगस एंड फ्रिवलस वन, filed merely, filed आएगा, not file, filed merely to squander public money wastage हो रहा है. coherent, being logical, clear. अभी देखिए, कोहेरेंट नैरेटिव, कोहेरेंट नरेशन दिया उन्होंने. द जजमेंट मस्ट प्रेजेंट अ कोहेरेंट नैरेटिव एंड मस्ट बी बैलेंस इन प्रेजेंटेशन एंड एनालिसिस ऑफ द इशू इन्वॉल्व. कोहेरेंट मतलब आप पूरा क्लियरली बता रहे हो, कोहेरेंट नरेशन देना कोर्ट में. समटाइम यू कैन से वो ही हैज मेड कोहेरेंट सबमिशन, मतलब पूरा डिटेल में बताया. कैटेलाइज मीन्स टू एक्ट एज अ ड्राइविंग फोर्स. The court landmark ruling on is science का word है. Those who are from science background, they will know. The court landmark ruling on environmental regulation served to catalyze subsequent amendments to state pollution control statutes. Statutes का मतलब भी law होता है. The court landmark ruling on environment related बताया, catalyze उसको join किया word, और state pollution, जब भी pollution होता है तो ये जो कोर्ट का जो जजमेंट है वो कैटेलाइज करता है कि उसमें अमेंडमेंट क्या होनी चाहिए. तो दिस वाज ऑल फॉर टुडे. नाउ वी गो टू द नेक्स्ट पार्ट. जस्ट अ मिनट. Just give me a minute. We all are lawyers and everybody wants to progress. That is including me and all the 259 people here today, this time. There is nothing wrong to expect success and go ahead in the life. I will give right now one example of the Harish Salve sir. Those who are regularly reading newspaper, he is a Queen's Counsel. अब क्वींस काउंसिल क्या होता है? इन इंग्लैंड देर इज अ रूलिंग, इट इज रूल्ड बाय क्वीन, रूल करती है वहाँ, किंग नहीं होता, एवरीबडी नोज दैट. सो उसको क्वीन काउंसिल बोलता है, यानी रानी का वकील. नाउ हियर आई विल टेल यू सम वन मोर थिंग, दैट व्हेन, just a minute, when he has reached to a stage by his hard work and become a queen's counsel in today's world, तो उनका नॉलेज को कितना, मतलब कैन यू मतलब हम, वी कैन ओनली रिस्पेक्ट अबाउट हिज नॉलेज, about the way he delivers in the court, of the speech, I would say arguments, submissions. That is a queen's counsel. In India, we have designated senior lawyers. सीनियर तो एज में भी सब हो जाते हैं, देर वी कॉल हिम सीनियर साहब है, माय सीनियर. But designated senior lawyer is a total different thing. It is there in law where a lawyer is designated either by the High Court or Supreme Court. So you will also have this opportunity in your life if you work hard. Now, who is designated by the High Court or Supreme Court? Now, any lawyer who has a special knowledge, who has attained at least at the age of 45 and minimum 10 years experience, and also has some special knowledge about a special branch of law, or he has rendered very good services in the field of law. So the either the Supreme Court or High Court will recognize his work, and on his application or on its own, the court, that is the High Court or Supreme Court, may appoint him as a senior lawyer. मतलब उनको टाइटल देता है, ही इज डेजिग्नेटेड, डेजिग्नेशन देता है सीनियर लॉयर. So there are senior lawyers are designated by either by the High Court or Supreme Court. Now suppose you are practicing in the Gujarat, then Gujarat High Court will designate you. You cannot come to the Maharashtra, that is Kolhapur, or here the Chief Justice Mumbai Principal Bench, and get you designated. Previously it was done, but now it is not allowed. If you are from Gujarat, you will go to the Gujarat High Court at Ahmedabad. You are from Uttarakhand, you will go to the Nainital High Court. You are from Meghalaya, you will apply at the Meghalaya High Court for senior designation. Then there is a Supreme Court, which has no such bar of the which state. Supreme Court has the jurisdiction all over India. It can also give a designation as a respect to a lawyer practicing before it because of his argument, because of his good work in the field of law, or special services rendered. So it is very important and a very respectful thing that you earn that title of a senior designated lawyer. So everybody in life, at least this is what we should try to achieve after 20, 30, 40 years practice. And there was a talk in between why the lawyers who are recognized or who are doing good work at the trial court, why they are not designated by the high courts. There is some debate going on, but it's not that the high court ever refuse somebody because he or she practices at the trial court, but they do look at your work, what works you have done in the last so many years, how you are respected in the legal fraternity, and there is a committee. Supreme Court from time to time come out with the guidelines for the designation of the senior lawyer from the legal fraternity. Now, senior lawyer has few conditions which he should follow after once he is designated. Normally, we file wakalatnama as a lawyer in the court. But once you are designated, you cannot file your wakalatnama. You cannot accept the direct brief or client. You cannot directly, because the code says once you are designated, you are respected as a designated senior lawyer, and it is because of your knowledge that you are designated. So there is a monetary terms which is different. You cannot just because you are senior you will ask any fees. You cannot engage client directly. There is a reason behind it, because the seniority comes because of your knowledge and experience, and the court says that the court wants to get benefit from you of your experience to solve or to come out with a good outcome of any case. So as a senior lawyer, see, it is a duty of any lawyer to help the court to bring out the truth or the true situation or the truth in every case. The senior lawyer has a more duty towards the court to assist the court. The word exact word, right word is assist the court in coming to a satisfactory solution, either maybe sometime in mediation, or to bring out the true facts through the court's knowledge and help the court and assist the court in coming out or bringing out the true judgment which is actually as per the law. So senior lawyer cannot accept the brief directly. They cannot be engaged by the client. They have to appear in the court only with the junior lawyer who has to who will file the वकालतनामा and he can argue as a counsel. Senior lawyer को ये बोलते हैं तो counsel है, either senior lawyer or counsel. He is also respected as a उनको counsel भी बोला जाता है. And normally भी हम लोग बोलते हैं counsel brief when I don't file a वकालतनामा and I'm arguing the matter. Suppose Vandana has filed a वकालतनामा and she says कि मैम आप appear हो जाओ. Then court will ask me where is मैम आपका वकालतनामा. I can say I can appearing as a counsel brief. That means I'm in an advisory position. The original is Vandana. Original lawyer is Vandana as per Vakalatnama, but I can appear with her permission. But senior law is a total different thing. It is they are appointed by the courts and they have a lot of respect. Those who have visited the High Court, if not visited, please go to the High Court. I wear a different gown. They wear a different black gown in the High Court. उनका गाउन पीछे से स्क्वायर होगा और रेक्टेंगुलर होगा and they have a flat gown and it is of a very good material, much better than the regular gowns what we wear in the high courts. So their gowns will be different. So even यहाँ पर भी 3 पट्टियाँ होती है, यहाँ पर भी उनके कोट पे 3 पट्टियाँ होती है, आपको दिखेगा. You can actually find out. It is for the court also to recognize, because see, if there is a new judge appointed or the senior lawyer from Uttarakhand comes to the Maharashtra Bombay High Court, how Bombay High Court is recognized is a designated senior lawyer because of their gown से हम लोग पीछे वाले वकील उनको पहचान लेते, सीनियर सर है और सीनियर मैडम है. एंड दी फ्रंट इन द कोर्ट, बिकॉज उनका यहाँ का भी गाउन अलग से होता है, उनके जो स्लीव्स होते हैं वो भी अलग होते हैं. जस्ट चेक इट आउट एंड गो टू व्हेनेवर यू गो टू द हाई कोर्ट्स. नाउ देर आर मेनी थिंग्स दैट व्हेनेवर ए सीनियर इज अपियरिंग, ही उनको बहुत रिस्पेक्ट दिया जाता है कोर्ट में. तो ऑलवेज रिमेंबर इट्स अ टाइटल विच हैज टू बी ऑन. Now, I will add one more thing to this. That is, of the there are 41 total high courts in our country, 25 principal bench, other are the benches of this court. Now, if a high court judge retires of any bench, any principal bench, or from any high court, Kolhapur, or we can say Gwalior, Jabalpur, Jammu, Kashmir, they cannot practice in that high court. They all will go to the Supreme Court. Those who retire as a high court judge, they go to Supreme Court. Now, if you see the high court judge, they are also wearing the gown. Now that gown has to be returned back to the back. They cannot continue that gown. They wear simple gown till they are again designated by the Supreme Court of India as a senior counsel. So in Supreme Court, you will find many senior counsel, but they are actually retired judges of many high courts. So once you retired as a high court judge, you have to apply to the Supreme Court to become a senior advocate, designated senior advocate, because you retired as a high court. Normally उनको वो gown मिल जाता है, and then they are again called as senior advocate or senior counsel, but they will be designated only by the Supreme Court. So always remember, these are very important title of the senior designated lawyer or senior advocate, or we call him or her as a senior advocate. It is a title which कम से कम you may be first generation lawyer, you may be from a economically background जहाँ पर you are feeling कि I'm unable to do much, but nobody stops you from increasing your knowledge, doing your best to the clients, and whatever case comes to you, do your best. And the court do recognizes these services. There is an instance in the Supreme Court where a lawyer was designated while he was arguing the matter. This is a story. While he was arguing in such a beautiful way. The judges then and there designated him as a senior lawyer because he was arguing court. So if you do good work, the judges also recognizes, and this will help you to designate as a senior lawyer. So every lawyer should have at least this much aim to get yourself designated. Of course, there are cases where the people say, I cannot file the wakalatnama. But after so many years of practice, also if you still think I can file wakalatnama, I can't keep the juniors, then it is something I think you need to revisit your practice and do your best. and get yourself designated as a senior lawyer. It is very important. And there are people who says, I don't want to get designated. That is also all right. But I see lot of respect and आपकी खुद की भी जिम्मेदारी बढ़ जाती है. And you feel yourself happy, elevated that yes, I am a designated senior lawyer. And your name will reflect on the High Court website. तो जब आए हो दुनिया में तो इतिहास में नाम लिखा के ही जाना है. तो दिस इज द वे यू शुड डू इट. So thank you everybody very much. We had a question from Kapil. I think two questions.
Thank you, ma'am.
Yes, let Kapil ask the question. Thank you का हम लोग बाद में कर लेंगे. Yes, Kapil. What was the question?
Yes, ma'am. It was in accordance to Article 22, where it is mentioned that the accused must be produced in the front of magistrate within 24 hours. तो मैम वो 24 hours में traveling time include होता है या नहीं?
उसी को तो ट्रांजिट, अगर एंटिसिपेटरी बेल पे है तो ट्रांजिट एंटिसिपेटरी बेल एप्लीकेशन.
नहीं मतलब जहां से उसको
That
पकड़ा
has
है
to be
वहां से
excluded, no? Excluded. But they have to take
excluded.
permission. That is called transit remand. If he is arrested, transit remand exclude होगा. Suppose 36 hours, okay? तो पुलिस तो कोर्ट परमिशन देता है 36 आवर्स का, उसको लेके नहीं जा सकते. मारपीट दिया तो बीच में कहीं पर पुलिस वालों ने
That
ऐसे
was
भी
the only
बोलते
concern.
हैं. ओके.
और मैम वो जजमेंट में रेक्स करके वर्ड था, तो
हाँ
रेक्स
हाँ आता है.
मतलब
I'll
किंग,
explain
राइट?
that. It is again a
That is
different.
king, right?
I'll explain that.
That means rex, right?
Yes,
King.
we'll take it again up. Take it up.
Okay, ma'am. Thank you.
Okay, thank you everybody.
Thank you, ma'am.
Thank you.
Thank you, ma'am.
Thank you, ma'am.
Thank you.
Thank you, ma'am.
Thank you, ma'am.
Thank you so much, ma'am.
Thanks.
Thank you, ma'am. Thank you,
Thank you, ma'am. Thank you so much,
Ma'am.
ma'am.
Thank you, 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 ma'am. Thank you so much, ma'am.